Shalom. My name is Michael Decker, and I'm a lawyer within the law offices of Cohen Decker Pex and Brosh. Today, I wanted to discuss under the situation everyone is in due to the coronavirus outbreak internationally, and due to the various legal matters that arise because of this coronavirus outbreak. And under the umbrella of the legal matters that our office deals with, I wanted to discuss the specific issue of contracts that aren't being implemented due to what is known as force majeure. Force majeure is basically a situation that no party could foresee in advance and that causes the contract not to be implemented, not because of anyone's specific particular fault. The relevant clause in Israel is subject to the contract law remedies, and it's in section 18. And the relevant clause basically states more or less the following, and this is a paraphrase of section 18 to the contract law remedies. It basically says that if there was a breach of an agreement as a result wherein there are circumstances that the person that breached the agreement during the signing of the agreement did not know about them, was not able to know about them, was not able to foresee them, and is not able to prevent them, and that the implementation of the agreement under these circumstances is impossible or significantly different than what was agreed upon between the parties, it will not be considered a breach of agreement, and it will not, and there will not be any way to give a remedy for such a breach of agreement, or to implement such an agreement. So basically, in the situation we're in now, there are many contracts that are being canceled, such as trips or vacations that were scheduled now that were canceled, maybe event halls that there was a couple that wanted to get married and cannot get married in the event hall because of regulations limiting the amount of participants in an event. In these situations, I'm sure Section 18 to the contract law remedies will be implemented. It should be mentioned that until now, the courts in Israel were very they minimally implemented this section because of the principle of keeping a contract. And the principle of keeping a contract is such a strong principle that this section is usually not implemented. However, due to this very significant situation in the coronavirus outbreak and the fact that this really is force majeure, it is our opinion that this section will be implemented quite a bit after this coronavirus is behind us. Unfortunately, it is hard for us to determine specifically in general whether it will always be implemented or not, and therefore it would be wise for anyone that is dealing with a breach of contract due to the coronavirus and due to Section 18 of the Contract Law Remedies to consult with a lawyer about this. Another very relevant clause is in regarding to rental contracts, and it is in Section 15 to the use and rental law. In Section 15 to the use and rental law basically determines that if there is a rented property and the tenant is not able to use the rented property for the purpose of the rent due to circumstances that are relevant to the facility or to the entrance to the facility, and the tenants did not cancel the contract because of this, he will be exempt from paying rents for the time that the rent was unable to be implemented. And then it says that the landlord is entitled, after a reasonable time period, to cancel the contract unless he notified the tenant beforehand that he is negating the exemption of the rental fees. So basically, we see here a situation whereby Section 15 to the rental and use law allows a tenant that is not able to use a property at all to be exempt from paying rent because he is not able to even enter the facility. Therefore, this clause naturally will not be relevant to a tenant that's living in a property because he's living in the property. But it would be relevant, for example, to a tenant that's not able to enter a property because he signed an agreement and the date of his entering into the property fell on a date wherein he is in quarantine and he cannot leave his house, so therefore he cannot enter the property. So in a situation like this, he can argue that he doesn't need to pay rent for the time period that he is not able to enter the property. Other examples, of course, are malls that have shops that none of the shop owners can even go into their facilities at the moment, or restaurants and coffee shops where it is not possible for them to do takeaways, for example, and they cannot enter their facilities because of the regulations of the Ministry of Health. So in any case, we are sure that Section 15 will be used a lot after this coronavirus outbreak, and that the courts will accept Section 15 in many situations. But even here, of course, every situation and every case will be dealt with according to its particular circumstances, and therefore we suggest and recommend that you consult with a lawyer before taking any action. And finally, regarding everything that was said, I want to suggest before everyone and before both parties to try to reach agreements that are reasonable and that make commercial sense. For example, maybe to split the rent half-half so that the damage will be absorbed by both parties and not only by one party. And I'm sure there are many other arrangements, fair arrangements, that parties can agree upon during this time. In any case, you can contact us if you have any questions on the matter, and we thank you very much for your time.